How can a husband be married to his pregnant wife and not be the legal father? Well, that's a question that was answered by the Georgia Supreme Court today. Here's the story. A couple is in the process of getting a divorce. The wife gets pregnant through in vitro fertilization, donor eggs, and donor sperm. While pregnant, they get divorced. Mom has twins, but one child passes away after a couple of months and the other child survives. Now, the Georgia Supreme Court has ruled the husband has no parental obligations. He is not the legal father because Georgia statutes do not say a husband of an IVF baby is presumed to be the father. As a result, the husband is not legally obligated to that child. We spoke with the child's mother today about this ruling.
I was in shock because I was about and I have to work. But when I got home and I put my daughter to sleep, like 1 a.m, I read the entire document. And I was so upset I could not sleep. It's not fair to them. It's not fair. I don't even want to cry, but it's not fair. It's wrong. It puts them at a disadvantage.
So what exactly does this Georgia Supreme Court ruling mean for other in vitro families and across the state of Georgia? I mean, this is monumental. Let's bring in our expert tonight. Randy Kessler is his name. He's a family law attorney, a professor over at Emory. Randy, let me start first with this. Does this decision by the Georgia Supreme Court create some sort of a legal loophole for dads who want to get out of their obligations, who have a child through IVF?
I don't know. You know, that's the real answer. I don't think it's going to go that far, but right now the law is gray. It's really, you know, you got the old school and the new school. The Supreme Court's basically saying this law right here that says if you are conceived by artificial insemination, then you are determined to be legitimate. You know, parents have artificial insemination, but this law does not say if you use IVF. And that's what happened in this case. They used IVF, and the court said this law doesn't apply.
Bottom line it for us now. So with this decision, does this throw something in the mix that was unexpected in the world of family law in Georgia?
100%. I think until this decision, we all thought that if you have a child or the child is conceived during the marriage, that's both parents' child. This child was conceived during the marriage. Now, there was some dispute in this case. The court found that he agreed to the IVF. He says he didn't agree. So if he didn't agree and mom went out and got pregnant with somebody else's sperm, that's on her. The court found that he agreed. So if you agree to get pregnant, whether it's your sperm or somebody else's, historically we have always thought over and done. That's both parents, mom and dad are the parents.
But that's not the case as a result of this decision.
Right. That's right. It throws everything up in the air. And I'm going to be looking at it. I hope I don't have to look at it to defend some of these crazy kind of claims that you're talking about. But, you know, we've seen crazier. I've seen people falsify DNA tests to show that their husband is not the father only because they didn't want him to have parenting time. I've seen women who have children with, you know, athletes say that he's the father and then refuse to take a test or try to fake the test. You know, things that would be out of...
Things you wouldn't expect happen in family court because of all the emotions that are associated with it. Randy, appreciate your expertise. Thanks so much.
My pleasure.